context of the matter before me is this, that if litigants choose to use the clandestine means to procure information, such actions would heavily compromise the need for Article 35 of the Constitution and would obviously violate the other party's fundamental right to privacy and Article 31 of the Constitution. Had the petitioners followed lawful channels and procedures available in law in obtaining the information, then the question of violation of the respondent's rights to privacy, as alleged in the cross-petition, would not have arisen. Indeed, in Dubai Aluminium Company Limited versus Alawi, 1999 One Weekly Law Report, where confidential documents had been obtained by private investigators' agents by making so-called pretext calls, the judge held that there was a strong prima facie case of criminal or fraudulent conduct in obtaining the information involving breaches of the English Data Protection Act of 1984. And you'll read that, man. And the last decision I want to refer the court to on that aspect, you'll have time to read that, is a decision which interestingly was given in an employment matter. It appears as number 10 in the case of Nicholas Muturio Kemwa and others versus Judicial Service Commission, reported in 2016 EKLR. This appears as authority number 10 in our supplementary list and bundles of authorities. And at the end, your sister, Lady Justice Ndolo, at the very end of her judgment, this is what she had to say. At paragraph 80 and 81, she says, before signing off this judgment, I need to address an issue that, although not raised by the parties, is an important one in employment litigation. In their pleadings, the claimants produced some confidential documents belonging to the respondent in the form of minutes of the Judicial Service Commission and letters addressed to other employees of the judiciary. The first claimant, Nicholas Okemo, told the court that these documents were obtained from the former Chief Registrar of the Judiciary. While the Constitution of Kenya guarantees the right to information, that information must be obtained through legal means, and as held by Lenaola JSC then was in the case I've quoted before you, a court of law will not rely on documents that are improperly obtained. An employee who requires a document in the employer's possession can access it by production notice. The mode in which the claimants obtained their aforesaid documents was therefore improper and must be firmly discouraged. So, Your Honor, our respectful submission is this. The foundation of this private prosecution are documents that either A, they were stolen from the records kept by the county government, or two, were given by employees employed by the county government in a manner that breaches the provisions of the Public Officer Ethics Act and the duty of confidentiality. And, Your Honor, when you consider that Section 44 of the Public Procurement Act that governs this proceedings, the repealed one, the 2015 Act, sorry, the 2005 Act, the Public Procurement and Disposal Act number 3 of 2005, Section 44 provides that there's confidentiality with respect. Section 44 of the repeal now, the Public Procurement and Disposal Act 2005 is the one that governs those two procurements. All this information dealing with procurement is confidential under Section 44 and can only be disclosed or obtained in accordance with that Act. It is a respectful submission, therefore, that on those two grounds, and bearing in mind Article 50, Sub-Article 4 of the Constitution, Your Honor, you're very conversant with it, on evidence that is obtained irregularly cannot be used to abridge any person's fundamental rights. We urge you to expunge those documents from the record, and once those documents are expunged, there can be no basis for the application for the private prosecution. That is the